and researching case law. So let's start with the process of where does case law actually come from? So at the trial court level, we know that's where we put on our dog and pony show. That's where we put on the evidence, and the trier of fact decides who wins, right? So we get a final decision that way, or maybe we get a final decision through a summary judgment hearing where the court says clearly the law is in one party's favor or the other and there's no need to proceed to trial. So, do we get case law at this stage of the game? And so most of you, I'm sure, are shaking your head no, because the natural inclination is to say no. But actually, we do get law at the trial court level in two capacities. If it's a state trial court, sometimes opinions are published by the local clerk of the court. It's not binding law in that circumstance. We'll put a red X on it in that circumstance. However, you have the federal trial courts, which sometimes hear state court issues, and so their opinions are published in the federal supplement, and those are good law. So be careful. Just because it's a trial court doesn't mean we don't pay attention to their law at all if it's in the federal realm. Okay, so we've resolved our dispute at trial. The losing party files an appeal to the appellate court. Appellate court reviews the case and renders a written opinion. And remember, what the court reviews here is what we call the record. And what's included in the record is not new evidence, right? What's included in the record is what was presented at trial, so the evidence presented at trial, the documents that have been filed with the clerk of the court, and hopefully a transcript of the trial proceedings if one of the parties hired a transcriber, a court reporter, to come in and transcribe the proceedings. If you don't do that in a trial, it can be very difficult to then bring the appeal because the appellate court doesn't get to see everything that was said at the trial court level. So again, that's what's included in the record that the appellate court reviews, as well as the law that was argued and the way it was applied. So we get law at the appellate court level, right? That's one of the primary places we get law. So if at that level somebody loses and they're still not happy about it, they can apply to the highest state court. And the highest state court has discretion to either review the case or refuse to review the case. If they grant a hearing and they hear argument, they review the action of the lower courts, both levels, and render a written opinion. And so at that level, we could get law. So again, the first set of law there is from the trial court level. Then we could get law, that we usually get law from the appellate court level. And we could also get law from the Supreme Court level, right? Well, if we're unhappy with the state Supreme Court's decision, you can also, if it contains a constitutional issue, appeal to the United States Supreme Court to hear the case and review what happened. And if they grant hearing and render a written opinion, then we get law at that stage as well. So one of the most important things to keep in mind when you're looking at case law, and I know you already know this, but it's good to be reminded, is you have to look at what court wrote the opinion that you're reading and make sure you know, is this mandatory authority for me or is this persuasive authority for me? Okay, so some other things to keep in mind, just like we were just talking about the concept of stare decisis or precedent, we work on a system where we follow the law that was decided before us if it's in our jurisdiction. So again, you have to take that time to say, what court am I in, who's writing this opinion, and is this binding on the court that I'm presenting it to or not? I want to take a second and talk about the steps that an appellate court can take so that you understand the procedural rulings that appellate courts make in case law. So an appellate court can affirm a decision, they can reverse a decision, and they can remand a decision, or they can do a combination of these three things. When a court affirms a decision, that means that they're saying, we agree with the decision that the lower court made, and sometimes they give us a reason why, sometimes they don't. A lot of court opinions are called a per curiam affirmance. A per curiam affirmance means that the court says we agree with the lower court and we're not going to give a reason why. So you will see literally the whole opinion just says per curiam affirmance. If the court reverses the lower court's decision, most of the time they're going to give us a reason why they're reversing that decision. And then they may also remand it back to the lower court. Most often, this is either to determine damages or to take in new evidence, because remember, appellate courts don't hear new evidence. Okay, so one of the other things we got to keep in mind when we're looking at case law is official versus unofficial publications. An official publication is one that is sanctioned by statute or court rule, or it's printed by an actual government entity. The official reporter for Florida state cases, for example, is the Southern Reporter. Now, unofficial reporters are not published by a government, or they're not sanctioned by either statute or court rule. Now, West, or the West Law Company, is the leading publisher of unofficial reporters. Typically, we cite to the West reporters, even though they're the unofficial reporters, because they are the more universally recognized citations. So, even though it's counterintuitive, we do actually most often refer to the unofficial reporter. So in the end, you need to check Blue Book to find out which one to cite, because Blue Book takes the different state rules about how to cite and puts them together, and so it will tell you whether or not the state requires you to cite to the official reporter or to the unofficial West reporter. Okay, so what are the differences really between official and unofficial reporters? Well, if they are all, official or unofficial, citations to the exact same court opinions. So it is the same court opinion, same written language in either the official or the unofficial reporter. The primary difference is that the unofficial reporters are usually published more quickly, and they have editorial enhancements like headnotes and key sites that help you look at the subject. So they have all these extra things that make a case more usable and more digestible. Of course, we're talking about government versus commercial. Of course, government is going to be slower than commercial in getting things put out for public consumption. Some courts require citations to both. Now, how do you know what your court requires you to cite to? You have to look at the rules in that court. So, sometimes those rules are listed in the procedural rules. For example, in Florida, our citation rule is 9.800 in the Rules of Appellate Procedure, and that applies to all courts in Florida. Other places, you actually have local rules. So, the district court itself or the circuit court itself might have specific citation rules. So, if you're working in a court that you're not used to working in, you need to go find their local rules and make sure you comply with them. Okay, so let's just look at an example here so that we understand official versus unofficial reporters. United States Supreme Court cases, there are 3 publications that publish those decisions. The official reporter is the United States Reports. That is the name of the publication. That is put out by the U.S. Supreme Court. The unofficial reporters are the Supreme Court Reporter and the United States Supreme Court Reports Lawyers Edition. We shorten that and just call it the Lawyers Edition. So one of those is owned by Westlaw and one of those is owned by Lexis. There's no need to know the difference between which is which. But so you'll see the official reporter is published by the government, and the 2 unofficial reporters are published by somebody who makes money off of them. So if we're looking at the Campbell case, you'll see even at the top of the Westlaw printout, it has all of these parallel citations, right? And it's all these series of numbers and letters. And I just want to make clear that all of those cite to the same case, the same language written by the court. It may not look the same at the beginning, again, because when we have those unofficial reporters, it comes with the editorial enhancements such as headnotes or summaries at the beginning. So, 510 U.S. 569 is the United States Reports citation. So, in other words, that's where this case, the Campbell case, is located in that publication. The 114 SCT 1164, that is the Supreme Court reporter citation for the Campbell case, and the lawyer's edition citation, which is the one on the furthest right, is the place where this case is located in the lawyer's edition publication. So let's talk about some other federal reporters that are out there. The federal reporters are fewer in number but higher in volume than the local reporters. So the primary source for federal cases lies in two publications, the Federal Reporter and the Federal Supplement. The Federal Reporter contains opinions written by judges in the United States Courts of Appeal. The Federal Supplement contains opinions written by judges out of the United States District Courts. And remember, when we were looking at that slide with the process, the appellate process, I mentioned that the United States District Courts, even though they're a trial court for the federal system, can be an appellate court for lower state court issues. So that's why we publish their opinions even though they're at the trial court level. So we also have the federal rules decisions, which includes administrative opinions by administrative judges about issues that come out of the regulations. So we have this quasi-judicial process that happens on the administrative side, which, let's look at an example. That's the best way to think about this. If you have a particular factory who's emitting too much carbon, the first people they actually answer to are at the Environmental Protection Agency. So we don't immediately go to court, in other words, go to a U.S. District Court and file suit against them in federal court. We actually go through the administrative side. So the administrative agency has its own quasi-judicial system to try and get that remedied. If it can't be remedied in the administrative side, then a lawsuit will be brought in the United States District Court. So just remember that there's that quasi-judicial administrative side out there, and we also get published decisions from them. Okay, so when we're talking about state law, remember those are published in regional reporters. And remember, we said they may not be the official citation, but most of the time that's what the local rules require you to cite to, is the regional reporter, because it's a more universal citation system and it just makes sense. It makes it easier. So as I flip through these, you're going to see that they are labeled by region and they include states in that region. So the one that just popped up here is the Southern Reporter, which includes Alabama, Florida, Louisiana, and Mississippi. And so each of these is by region, and you'll see the Southern Reporter, you'll see the Southern Second Reporter, and now you'll see the Southern Third Reporter, and you can see that in any of these regions. And I just want to explain that quickly. When you see the second and the third, it just means they ran out of volume numbers in the first series, and so they had to go to a second series and then a third series because all the volumes were